Good morning. My name is Christopher Warham. May it please the court, I'd ask to reserve for 5 minutes for rebuttal. This case is very unique in one very serious respect. The jury in this case never heard why the initial child alleged victim entered the principal's office and actually said what had occurred. In fact, it was a completely false narrative. It was done as though the child was coming into that principal's office out of moral courage. I can't take it anymore, and this is what's happened to me. I have been sexually assaulted. That is a completely false statement, and that is what the jury heard. What was the truth? She was brought into the principal's office because her mother had been whipping her with an electrical cord. That was sustained. And when she was brought into the office, she immediately deflected and started to say that was my client.
Okay, so I understand the argument, and I agree with you that there's some irregularity here, but was this presented on direct appeal?
Yes. This was presented on direct appeal. It was argued. Oral argument occurred on direct appeal. And in fact, it was Justice Cherry during oral argument who asked the prosecutor, weren't these facts completely false? And it is, I've cited to it in the brief.
But then
yes.
The Nevada Supreme Court has this long footnote at the end, and one of the middle paragraphs of that footnote says that they didn't view this issue as having been properly preserved, citing, portions of their of their state appellate rules. So is it procedurally defaulted?
No, it is not. And the district court below in this case found that that was completely improper, a completely improper...
By the Nevada Supreme Court?
Correct.
Okay, but let's take this seriatim. You don't disagree that the Nevada Supreme Court said it was not properly presented on appeal?
That's exactly what they said.
Okay. So if they're right, then it's procedurally defaulted.
How could they possibly be right?
Okay, that's not my question. If they're right, and it's a question of Nevada state law, right?
Well, I disagree because it was a federal issue, and as the district court...
But the question of whether it was procedurally defaulted, the question whether it was properly presented is a procedural question under Nevada rules.
Well, I just don't see how it was not possibly presented correctly because the whole trial transcript was in there, and you can see from the trial transcript this is a complete falsehood. And so it was argued as though the trial transcripts itself show the falsehood. And in fact, trial counsel asked in the middle of trial for reconsideration, and I have this in Volume 9 of our...
But the Nevada Supreme Court... Okay, so... You're saying that this is false. The Nevada Supreme Court said that it had failed, that Thomas had failed to provide the district court's disposition on the issue in his direct appeal in accordance with Nevada state procedural requirements.
And that is inaccurate. It is completely inaccurate because it's a direct falsehood. In other words, what the argument was this was a violation of your right of the...
Even if you're right, I just don't know how to, I'm trying to get a paradigm here for how to decide this, because even if you're right that is false, it has to be in order to have a habeas claim, it has to be a violation of a clearly established federal law. So I don't understand how you get to that threshold. I mean, at first I'd say, look, this is Nevada applying Nevada rules. They cited 3 or 4 cases. I mean... Are we supposed to dig into that and say, well, no, you just, at best, what you can get is us concluding, as the district court apparently did, that Nevada misapplied its own rules.
Correct.
But how is that a violation of clearly established federal law?
Because as the district court below in federal court said that they didn't even consider the federal issue. What they did is they completely ignored the federal issue, decided we're not going to hear this.
Right, but they did it based on a state procedural default, effectively.
But it can't be, because what they're saying is that the issue, they couldn't read the record enough to tell what the issue was. But the issue was the falsehood. And I have where defense counsel in trial asked the court to reconsider. It's right in the trial record. The Nevada Supreme Court had it. And when Mr. Mann, trial counsel, said, this is something that's happened, it's false, I want to be able to present it. And the district court responds, I don't know if you, and I admonish you. So here, it was clear in the record to the Nevada Supreme Court, clear. All they had to do was read it, and they could see the federal error, that there was a false narrative taking place, and they just completely ignored it.
I have a minor question. Is the entirety of the appellant's appendix that was filed with the Nevada Supreme Court, was that submitted as part of the record to the district court in connection with these habeas proceedings?
Yes. Let me see if I see the nuance.
You filed, when the appeal was filed in the Nevada Supreme Court requires this appendix to be created under its Rule 30.
Correct.
And a massive 26-volume appendix was prepared and submitted. Is that appendix in all those 26 volumes, is that in the record of the district court in this case?
Yes.
Okay.
And that's why the district court, in this case, the federal district
Was that
court.
submitted with the habeas petition, or did the state submit it when it submitted the records?
I believe I submitted it, and it was submitted. But if you looked at it and somehow it was wrong, I wouldn't dispute that. But I believe the entire trial record was in there. And the district
No, I
court.
wasn't asking the trial record. I was asking this 26-volume appellate document that was filed in the Nevada Supreme Court. So we would know what the Nevada Supreme Court had in front of it.
Yes.
When it made this comment.
Yes. And what I'm missing and don't completely understand at all is when you read the trial record, which was before the Nevada Supreme Court, it's clear as day. They just ignored it. All that one justice asked, and then 6 of them agreed, or 7 of them, was that the order itself, the pretrial order, was not in there. Yet you can see in the record that what took place was a completely false narrative. If the jury was back here, the jury listening to this, they'd say, what is this man talking about?
We have this right here, and why is he saying it's not here? That's your position.
No, what I'm saying is that the jury would think, what is this case about? That child had the moral turpitude to walk into that principal's...
Turpitude, courage.
Courage. Had the courage to come in there. But that was a falsehood.
But can you, I want to take you forward to, can you address Judge Dorsey's determination that this didn't meet the Brecht standard?
Yes, it's really interesting as you look at it, where she missed out, and that's why I concentrated it on. She said that reasonable minds could differ, but she never addressed the very fact that of the 4 accusers, AP, half the verdicts were not guilty. 1/3 of ZF verdicts were not guilty. 1/3 of MS, not guilty. All of MSB, not guilty. So when she was doing the harmless error analysis, she failed to recognize that if this jury that obviously was skeptical, had skepticism, this would have been the tipping point, the inception of the case, the right under...
But one of the 2 other accusers that she relied on, they were actually all acquittals. Is that
No, I agree with you in part, so I'm accurate. The other 2 she did not consider. All of MSBs were not guilty, and 1/3 of MSs.
Right, but okay, I'm trying to understand your argument. So as I understood Judge Dorsey, what she said was that, this would have impaired the credibility of these 2 witnesses, but there were 2 others, and that's more speculative, and therefore this doesn't meet Brecht. But part of your response is that for one of those 2 other ones, they were all acquittals? Do I have that correct?
Yes, and that she didn't consider that she didn't consider that this jury had been very close. It was obviously a very close decision. And under Davis versus Alaska...
So I'm trying to understand, just to finalize this point, is your argument... because I guess at one level you could show that he still wouldn't have gotten convicted on the first 2 tests. Under your theory, he still wouldn't have gotten convicted on the first 2 the first two witnesses?
No, because the jury never got to hear why the revelation occurred. They never heard this. It was a falsehood.
Right, no, that's my point. I think this is your argument, is that he was convicted on the testimony of the first two. There were convictions, even though some of them he was acquitted on. There were convictions, and those would not have happened, in your view, if this had come in.
Correct. That's absolutely right.
So, in a way, is harmlessness even at issue here? Because, I mean, your point is he was convicted on, how many total grounds was he convicted on across all four witnesses?
I did not count them.
Okay.
I did not.
But you're saying if it was 20, it might have only been 10, and that's a material difference.
No, I'm saying that I believe that if the jury had known why the inception of the revelation came, that he would have been acquitted of all charges, because
Do
then
you have to prove that to be successful here? Do you have to prove that he would have been acquitted of all
No.
charges, or just some charges?
No.
Because I think you've got a pretty heavy burden.
Substantial.
And you've got a heavy burden to say that he would have been acquitted on all of them.
I have to show substantial and injurious effect. And under Davis versus Alaska, motive and bias carry a unique constitutional principle. He had his entire theory of defense gutted. And not only that, but what's more importantly, and this is where the Nevada Supreme Court just completely ignored the transcript. The prosecutor was permitted to get up and mock the defense for lack of motive, including saying things like, oh, are they saying the mother was vile? Well, the answer that you would imagine defense counsel at trial wanted to scream out is yes, she was whipping her child with an electrical cord. You're presenting a complete false narrative to a jury that this mother was a caring mother, and they're mocking the defense. Mocking the defense as to you have no motive. The prosecutor even said it. And I laid out 10 times in closing argument, the prosecution mocked the defense and did it in a false narrative. We had a trial that the Constitution does not permit to let a man be convicted on a completely false narrative and then judicial overreach, and then let prosecutors mock the defense, and at the same time have a judge who is telling defense counsel, I admonish you. He could do nothing. This is all in the record. The Nevada Supreme Court had all of this information.
Okay. Do you want to reserve time for rebuttal? Okay.
Thank you.
I know you were just getting wound up, so I hate to cut you off when it was just getting good.
Thank you. I'm sorry.
All right.
Good morning, Your Honors. May it please the Court, my name is Katrina Lopez. I'm appearing on behalf of the respondents' appellees in this matter. This Court should affirm the decision of the Federal District Court and deny Thomas habeas relief for two reasons. First, the Federal District Court correctly concluded that any error by the trial court in excluding the evidence was harmless under Brecht. And two, in the alternative, the Nevada Supreme Court, applying its own state procedural bars, rejected the claim.
I want to understand the procedural bar. What's the answer to my question? Is the 26-volume appendix that was filed in the Nevada Supreme Court, is that in the district court record of this case?
The appendix, yes, Your Honor. It was provided to the Federal District Court.
Okay. But if it weren't, I mean, it's available online because the Nevada Supreme Court actually lets you see all the PDFs, so you can pull them up and look at them. We could look at them even if they weren't they'd be subject to judicial notice, correct?
Yes, Your Honor.
Okay. So what exactly did he not put into the appendix that got the Nevada Supreme Court upset? Because they say we are unable to evaluate Thomas's arguments regarding the precluded evidence and motion for independent psychological evaluations, which is a separate issue, because he has failed to provide the district court's dispositions, either in the form of orders or hearing transcripts, in order for us to determine the existence of errors. So what is the document that he should have put in that they found that he did not put in?
Okay, yes, Your Honor. So in 2 SCR 531, that's the actual appendix that was presented to the Nevada Supreme Court on direct appeal.
I'm sorry, 2 SCR what?
531. That's the appendix.
Okay.
And so from reviewing the appendix, there are two things that are missing. I referenced one of them in 8 SER 1822 to 1823, and that is the March 10th, 2006 transcript from the supplemental briefing. That's the minute order.
Correct.
And then, so there's a transcript. Obviously, there was arguments held. That was not provided to the Nevada Supreme Court.
On the arguments that are reflected in this minute order.
Yes, Your
Correct.
Honor.
Now, let me stop you there, because this document that at 8 SCR 1822 is in fact in the appendix. It's volume 26 of the appendix, page 4555. It's in there. I pulled it up, I looked at it. It's there. So this statement by the Nevada Supreme Court is just completely wrong. The document is in fact in the appendix, they just missed it. Indeed, the government, in responding to the appeal in the red brief, cited this very document at exactly that page. I don't see how the Nevada Supreme Court could say that the document was not presented to them when the government itself pointed to it in the appendix and said that's where the document is.
But, Your Honor, it's not just the transcript from the March 10, 2016 date. There's also the order missing from April 12, 2016, which is referenced in the record 8 SER 1820 through 1821.
You're correct. That is not in the appendix, but that order is completely devoid of reasoning. This is a form conclusory order that was submitted by the government that the judge signed. The only document that has any reasoning in it is the minute order, but the minute order is in the record. So the Nevada Supreme Court said we've not been provided either in the form of orders or hearing transcripts when they did in fact have the order. So this whole procedural default is just based on a patent misreading of the record. So that says to me that we just set this all aside and we're now then in de novo review, are we not?
Well, Your Honor, it's still the respondent's position that the claim was still presented to the Nevada Supreme Court, specifically in 2 SER 464 to 481, and in his reply brief in 2 SER 327 to 334, and I'm paraphrasing, Thomas basically says that he was denied his fundamental right to present a theory of defense. So it was presented to the Nevada Supreme Court, not just in the heading, but in the briefing as well. And so the Nevada Supreme Court, not having the order as far as the disposition from the underlying motion in limine, they rejected the claim. And that is what makes it procedurally defaulted, because you still have to comply with Nevada Rule of Appellate Procedure 28A10A and Nevada Rule of Appellate Procedure 30B2 through 3, which states that you have to have the requirements of the contents for the appendix on appeal as well as cite to the record, the entirety of it. Because when you're dealing with this claim...
So you are correct that in the opening brief in the Nevada Supreme Court, they did not cite the minute order. They cited the portion of the later transcript where she reaffirms the order and says, you haven't shown anything to change it. But then the state files its brief, and in discussing this issue, cites and discusses the minute order and points to where it is in the record. And then we get this comment from the Nevada Supreme Court that says, we're unable to evaluate it. We just can't do it because you didn't give us the order, when if they had read the briefs in front of them, they would see that the order is in the record in front of them.
And so, Your Honor, even if this court disagrees and states that the claim is not procedurally defaulted, that the minute order as well as the transcript in essence was provided to the Nevada Supreme Court, Thomas is still not entitled to relief because the federal district court on de novo review correctly concluded that any error was harmless under Brecht. When you're looking at Brecht...
What's your response to his argument that, well, Judge Dorsey pointed out that this wouldn't impair the credibility of two other people, but one of them, actually all the claims were rejected anyway, and the other... a proportion of them, so this actually was a lot shakier than she seemed to realize.
Well, Your Honor, if we're talking specifically about the counts in this situation, you have counts 1 through 10. They apply to the victim AP. And so when you're dealing with the counts 1 and 2, counts 5 and 6, and counts 7 and 8, they were alternative. So it was a situation where if you didn't find him guilty of sex assault on the alternative count, it was lewdness. So that is why he could not.
This is one of the, I'm sorry, this is one of the third or the fourth witnesses?
Yes, Your Honor, AP. And so when you're looking at these alternative counts, he could only have been convicted of 3 of those with respect to the 6. Because there are alternative counts. You cannot be convicted of both because they're 2 different sexual acts from one sexual encounter.
Okay, so your point is he was actually convicted of 50%, not 30% of the charges.
With respect to AP, if you're looking at the fact
and with
that
respect to the other witness.
Well, Your Honor, if you're looking at her sister ZF, he was found, the counts pertaining to ZF are counts 11 through 15, and he was found guilty of 4 out of 5 of those counts. And then
Which of the counts, because the verdict form doesn't say what victim they applied to. Which ones are the MSB counts?
Well, Your Honor, on if you're looking at the jury instructions, they are unredacted and they have the names of the actual victims.
They're in the jury. That'll tell us which one. Okay.
Yes,
All right.
2 ER 125 to 161.
Okay, I have that.
And then so with respect to ZF, her sister, that's 4 out of the 5 counts. And then you have MS, that's counts 16 through 21. And he was found guilty of 3 out of 6 of those counts. And then you have MSB, which was the remaining counts 22 and 23, and he was found not guilty of both of those counts.
Okay, so, but isn't his argument that, look, if this evidence had come in, as to AP, 3 of the 6, your position is 6 of those were on the table, he was convicted of 3 of them, he could have been acquitted of 3.
Not necessarily, Your Honor, because when we're looking at Brecht, we're looking at did the exclusion of the evidence, did it have a substantial and injurious effect or influence on the jury's verdict, and not so. Because
but wouldn't the jury's verdict, I mean, if he was convicted of fewer counts, wouldn't that affect the jury's verdict? That's what maybe I'm just completely off base on that. But
well, no, not necessarily, Your Honor, because even if you look at count 8, which pertains to AP. Count 13, which applies to ZF, the witness in question. And then if you look at count 17 through MS, these are 3 separate girls, 3 instances in the state of Nevada where they were sexually abused by Thomas. And if you look at the charging language, he was convicted of lewdness with a child under 14, and it involved him using his fingers and or hands to touch and or rub and or fondle the genital areas of these 3 girls. These 3 girls, they attended the daycare that he worked in. These 3 girls, their parents were the friend of the defendant. These 3 girls, they were staying at his house.
My question is more fundamental. Does he need to show that it would affect every count? He was convicted of 10. He was convicted of 10 counts across all 4 girls, right? Mm-hmm. Does he need to show that all 10 counts he would have gotten an acquittal, or could he just show 5 counts he would have gotten an acquittal? Wouldn't that be enough for habeas relief?
He wouldn't have to show all counts, but, Your Honor, just because he was found not guilty on some charges, that doesn't absolve his guilt.
That's not my point. My point is, if we assume that it would have had a material effect, and we will have to make that determination, but if we were to assume or find that it had a material effect as to AP and ZF, why wouldn't that be enough to say it would have affected, in that case, it could have affected 7 of his 10 convictions if we think that the jury would not have reached a conviction on 7 of those 10?
Then, Your Honor, it would go back to the timeline. So when we're looking at, with respect to AP and ZF, they allege that they were sexually abused by Thomas from January 2006 to January of 2010. But then at some point, ZF moves to Arizona. But what opposing counsel is missing is that ZF discloses sexual abuse to her sister, AP, first, before it was even disclosed to the principal. She told her sister that
Your point is that this still would have come in another way, even if the principal, the evidence had come in that she was called into the principal's office because of beating by the.
Yes, Your Honor, because she already disclosed to her sister months before.
I think that goes to the harmlessness question of whether he could have been convicted. But I just have a threshold question, and that is, even if his alleged error only affected half or 60% of the convictions, if we thought it had affected those, we would grant relief, wouldn't we?
You would, but we would still have to take into consideration
I understand.
MS's testimony.
I understand. Okay.
And so when we're looking at, Your Honor, the fact that...
How does MS's testimony affect AP and ZF? Just because it makes it more likely to have happened anyway, whether or not the beating had been properly presented.
When you're looking at MS's testimony, Your Honor, there is nothing in the record that shows that MS was related to AP, ZF.
No, I give you that. I'm saying those convictions would stand, but the other 7 are questionable under his theory. But that's a big difference to Thomas if he gets released or if he gets habeas relief for 7 of the 10 convictions. I imagine that would have a material effect on his sentence and everything else about this case.
No, Your Honor, I understand that position, but again, our
I'm
position...
just saying you don't get there because there's other evidence that supported it, even if you were to discount what was said in the principal's office.
Yes, Your Honor, because when we're looking at the timeline and we're saying...
I just don't understand how MS is one of those pieces of evidence that supports AP, the AP or ZF. What you said about AP telling ZF later, that makes sense to me. Mm-hmm. But I don't understand how MS is evidence, other than the fact that it corroborates that he had a propensity to do this.
Yes, all it does is strengthen the evidence which goes against his argument that there was speculation or fabrication as far as the sexual abuse deflect from April. Because when you're looking at April, it was one isolated incident. April disclosed the abuse to the principal the next day. She confessed 9 days later, but all of this occurred before Thomas was even arrested. So when we're looking at this timeline, there is nothing, which the Nevada Supreme Court agreed, there is nothing to show that there is a correlation between the disclosing of the physical abuse and the sexual abuse done by Thomas to these 4 girls in this instance. It's speculative at best. And if there's no more answers from the court, the respondents would respectfully request that this court affirm the decision of the federal district court and deny Thomas federal habeas relief.
Okay, thank you.
Thank you.
Federal District Court found, and I'm quoting from page 16 of the order, finally, April's abuse of ZF amounted to a major part of what otherwise would have been Thomas's best defense. His best defense was excluded. And you're talking about the 2 other...
But how does it impair, I mean, the problem I think that Judge Nelson's question was focused on is how does this impair the counts with respect to MS? How is there a collateral spillover to her credibility? She has no connection.
Here's why. She didn't come forward voluntarily at some other time. The way that occurred, and the record will bear it out, is once this was a daycare assistant director, so it made quite a bit of headlines, as you could imagine. And then the mother of MS and MSB started to ask the children, did this happen to you? Then the revelation came out. So you can already see the bias. It starts with the inception.
But you had the ability to completely make that argument to the jury. I don't see how that argument as to MS is enhanced by having this come in as to AP and ZF. That's what I'm struggling with.
It most certainly does, because what you've done is you've taken away... The district court at trial took away the ability of his best defense to
his
make...
best defense as to AP and ZF.
Oh.
I don't... I think we're asking the same question. And
No, if the first two are false, if the two have manufactured to deflect away from their mother, then it comes out, and we've seen this in other cases where all of a sudden children will come out and say, yes, something has happened, something has occurred.
But you had the ability to make that defense, and the fact that you had a theory that AP and ZF were covering for the mother because of the abuse allegations and all that was kept out. Just, if all that comes in, how does that rationally affect MS's credibility in a way that's different from what you already had to be able to argue?
Because it would show that the very inception of the case was false. It was a false narrative. And the defense attorney could never make that case. If I could argue to a jury and say...
But the problem with that, I understand your argument, but the problem is you're basically saying he gets a get-out-of-jail-free card on any other harm that he committed because of, these first false, assuming your argument is true, because of these first false claims. And I mean, that can't be true. But, I mean, two things could be true. He could be falsely accused of the first two, and he could actually have done the second two, or at least the fourth or whatever.
Well, all of a sudden I realize that the court is completely speculating. Wouldn't that be in the province of the jury? It invaded the province of the jury. One of the constitutional rights that we have is to have a trial by jury that
Under Brecht, you have a burden. You have a burden to show that it, had substantial and injurious effect. And the question we're struggling with is, how does something that undermines the credibility of AP and ZF, how does that rationally create a spillover that creates a marginal difference in the credibility attack on MS?
Because it's like a domino effect. Once that first domino goes down, all of a sudden everything else gets affected. And you think to yourself, maybe these other children are like going along with the mother. Yes, something happened. Remember, the jury was very skeptical of what was occurring in this case. They found MSB him not guilty of all of them, and then found acquittals on excuse me.
Yeah, but there's 3 convictions on MS. That's the problem.
And the domino effect was taken away, the right to trial by jury.
No, but you can't just say domino. What's the rational chain of thought by which a jury could say, okay, AP and ZF were covering for their mother, and how does that now impair the credibility of MS in a way that wasn't already available?
Because it became a situation, you also saw that there were lawsuits. It became a situation where there were lawsuits in this case that children started to go along with their mother asking them. They didn't come forward and say, hey, this happened to me. The mother started saying, did this happen to you? And from that, I know wouldn't repeat domino effect, but it's taking away the best defense the man had. And the jury had a false narrative. They lived in a vacuum of falsehood, and that shouldn't happen under our Constitution. It shouldn't. And I realize I've taken up more time.
No, we took you over. Thank you. Thank you for your arguments. Thank you to both counsel for your arguments. The case is now submitted, and that concludes our arguments for this morning.
All rise.